Hello, my name is Crystal Dahl and I am the Online Communications Manager here at Meritas. I would like to welcome and thank each of you for joining us on today's webinar, Not Up in Smoke, Employer Rights in the Face of Legalized Marijuana. For those of you unfamiliar with Meritas, Meritas is an established global alliance of closely connected yet independent law firms that each offer a full range of high-quality, specialized legal services. We were built upon a rigorous system for monitoring and enhancing the quality of our member firms and have been connecting clients with carefully qualified business legal expertise in over 240 markets around the world since 1990. Meritas Capability webinars are regularly presented by Meritas members. Before we get started, I'd like to quickly go over a few housekeeping items. Meritas offers the ability to listen to our webinars through your computer speakers, but if at any time you have difficulty hearing the presentation, you may call into the associated telephone line instead. All phone lines will be muted. If you experience any technical difficulties, please press *0 at any time to connect with a support technician. Since you will be muted, if you have a question, please ask via the chat feature found on the left-hand side of your screen. The presenters plan to answer questions at the end of the presentation. Lastly, in the next few days, I will distribute a copy of the presentation, a recording of the webinar, as well as each of the presenters' contact details. With that, Kelly, are you ready to get us started?
Yes, thanks very much, Crystal, and good afternoon, everyone. My name is Kelly Van Buskirk. I'm speaking to you from hot and sunny St. John, New Brunswick, and I'm very happy to have this opportunity not only to speak with you, but to hear from several lawyers that we've had the very good fortune of working with through our association with Meritas, the organization that Crystal described. First today you'll hear from Trina Fraser, who is the co-managing partner at Brazos Seller Law in Ottawa. Trina is a graduate of Queen's University, where she studied both law and her Bachelor of Commerce degrees. She does a tremendous amount of work in the cannabis law area, is recognized nationally as a leader in this emerging area of law, and she's also a registered trademark agent. So we're quite thankful that Trina was willing to spend time this afternoon educating us in this important area of law. We're also joined by Tracy Kay at Minden Gross in Toronto, and Tracy again is a graduate of Queen's University in arts and then law. Tracy's been practicing in Ontario since the 1990s, as is the case with Trina, and Tracy represents a wide range of clients, many employers in Ontario and elsewhere, and again, we're very pleased that Tracy found time to help with this project today. The purpose of it being to assist employers in understanding the issues that surround marijuana and its impending legalization. Finally, you'll hear from Matthew Letson. Matt is my partner here in St. John at Lawson and Creamer. Matt has a practice that is focused in administrative law, workers' compensation issues, and also human rights and labor. So in Matt's practice, he deals significantly with workers' compensation issues and employee disability issues, and has been called on by workers' compensation boards in various provinces to analyze and comment on the impending legalization of marijuana. So those are the speakers you'll hear from today. As Crystal mentioned, feel free to type in any questions you have, and I'll bring them to the attention of the speakers. And with that, I'll turn it over to Trina and ask her if she will be willing to kick us off with with some thoughts on the upcoming legalization of marijuana.
Sure, thanks very much. Okay, so for my, portion of the presentation, I'm really just going to give you a quick overview of the history of where we're coming from as far as the legal treatment of cannabis in Canada and where we're headed in the near future. I'm not going to spend too much time on the history, but I do think it's relevant, especially in the employment and labor context, because you have accommodation obligations on employers that are really driven by the medical use of cannabis, and that's really how we've gotten to where we are today in Canada with cannabis. So I think it's important to have a little bit of an understanding of where we've come from. So we're basically coming off of nearly a century of prohibition of cannabis in Canada, and in fact, we included cannabis as a controlled substance in Canada 14 years before the U.S. did. There's some interesting kind of theories about how and why cannabis did get added to that controlled substance list when it did, and it is a little bit of a mystery, and there's a lack of parliamentary record on it, which is just a little curiosity that I'm interested in. So the current legislation right now, cannabis is controlled under the Controlled Drugs and Substances Act, which is a federal act. It is included in Schedule 2 to the CDSA. Cannabis, its preparations, derivatives, and synthetic preparations. And so some of the constituent cannabinoids in cannabis, THC and CBD, are also individually listed as controlled substances. Now, way back in, 2000, there was an Ontario Court of Appeal decision in R.V. Parker where Mr. Parker raised a constitutionality defense to a possession charge of cannabis, and he was successful in that challenge, and it was determined that the provisions of the Controlled Substances Act, which prohibited that, were contrary to Section 7 of the Charter in his case, because it essentially, he was a medical patient and he used cannabis for medical purposes, and it forced him to choose between his personal health and his liberty. So that was the implementation of the Medical Marijuana Access Regulations, the MMARs, in response to that decision in R.V. Parker. Leave to appeal to the Supreme Court of Canada was dismissed. And that system basically allowed people to grow personally for medical purposes, allowed them to buy from a government supply, or allowed a designated person to grow for them. And it went through various iterations and court challenges, and ultimately about 4 years ago in 2013 actually, but it really came online in 2014, the Marijuana for Medical Purposes Regulations, or the ACMPRs, came into effect. And that was the government saying, we really don't want to maintain a government supply here any longer, and the personal growing is a little bit out of control. There's a lot of diversion to the illicit market happening. We're going to privatize this industry with commercial producers, and they're going to produce exclusively for medical patients in Canada. That faced some court challenges as well, and ultimately it was held that, again, there was a constitutional invalidity there because it didn't allow patients to grow their own medicine. And that led to, in 2016, the introduction of our current regulations, which are the Access to Cannabis for Medical Purposes regulations. So that now we have a combined system, essentially. We have commercial growers. There's 94 commercial growers across the country, and we have people able to grow for themselves or have someone else grow for them if they're unable to. So yes, as I said, we have 94 licensed producers across Canada. There's a huge backlog with Health Canada in these applications. I spend a lot of my time helping clients try to progress their applications with Health Canada, and there's hundreds of them pending. We've grown now, the medical patients have grown up to over 200,000, and that's growing very quickly. And there are 11,000 of those are either growing for themselves or having someone cultivate for them. The rest are buying from licensed producers. This just gives you a quick overview of the geographic distribution of the producers across the country. As you can see, we've got a disproportionate representation in Ontario, and to a lesser extent in BC, and very few producers in other provinces right now. So this is there's a lot at stake here. There's a very big market. We've got tens of billions of dollars in market cap right now of the licensed producers who are publicly traded. There's been hundreds of millions of dollars invested in private companies that are either have licenses or are trying to get licenses. And the potential recreational market moving forward is, again, worth billions of dollars. So as I'm sure you all know, Bill C-45 is before the Senate right now, and that is going to be the all-encompassing bill that's going to become the Cannabis Act if passed, and is going to basically create a system in Canada to regulate both medical and I guess what we'll call recreational use of cannabis. So cannabis is being completely removed from the CDSA, and an entire separate framework is being created under the Cannabis Act. Adults across the country will be able to possess up to 30 grams of dried cannabis, legally obtained dried cannabis in public, and for the most part an unlimited amount in their homes, although that could be subject to provincial restriction. It will be legal for adults to grow up to 4 cannabis plants per dwelling, and again, unless restricted provincially, and Manitoba and Quebec have said no to that, but the rest of the provinces have given a thumbs up. Senators aren't necessarily convinced that home growing is a good idea, so we'll still have to wait and see if the Senate proposes any amendments to the home growing provisions. And the provision for production licenses remains. So, sorry, you probably can't see the detail on this very well, but just to give you, make the point that although we are legalizing cannabis, we're actually creating more offenses than we currently have with respect to cannabis. So what the government has tried to do is carve out a scope of legal activity with respect to the production and distribution and sale and possession and consumption of cannabis. But if you fall outside of that permitted scope of activity, there are still offenses that are going to be applicable. The ones relating to children, for example, are going to be the most serious, can result in imprisonment of up to 14 years. And moving down to the lesser serious offenses, which the new aspect of this from an offense perspective is that many less serious offenses, there will be a ticketing option. So you won't be facing a criminal charge and you won't have a criminal record, but you just may have to pay a fine. So there are many different licensing categories that are going to be available under the Cannabis Act. They're having to do with cultivating cannabis, processing it into different finished products, selling it into either the medical or the recreational supply chain, testing it, conducting research and development activities, importing and exporting out of the country. All of these things are going to be subject to different licensing categories, and so we still have yet to see exactly what the requirements for all these licenses are going to be. We're waiting to see what the regulations look like when they are published after the bill achieves royal assent, hopefully in June.
Trina, I wonder if I could interrupt for a moment. There's been a question asked, and perhaps it isn't the best time for me to interject, but the question is, how will there be a differentiation between legal and illicit recreational products?
Well, that's one of the questions that law enforcement is asking, and if you probably saw in the media last week that Health Canada has published some proposals as far as what labeling and packaging of legal cannabis is going to look like in this country, and I think it's definitely going to stand out from anything else you'd buy at a dispensary or elsewhere. So one way obviously is going to be, how is it packaged, and are you going to be able to prove through a receipt or other means that you purchased it from a legal source? And if you're a consumer of cannabis, that would be my suggestion to you to protect you from that type of a charge would be keep it in its original packaging, keep the receipt from the purchase to be able to prove that you bought it legally. But that is a concern of law enforcement, that ultimately they may not be able to easily distinguish between legal and illegal cannabis.
Thanks.
Okay, so I'm not going to get into the details of these licenses. Okay, so this is what Canada's standardized cannabis symbol is proposed to look like. It's going to be on every package of a product containing cannabis. This was released recently, and Health Canada has said that they went through studies with focus groups and looked at various shapes and colors, and really what this is a big stop sign essentially, and that was intentional, that tested well with children as a kind of a universal symbol that they understood to mean, have caution, don't go forward, don't proceed. So that's, obviously the industry isn't necessarily happy that that's kind of the way that cannabis is being portrayed through this symbol, but the government is taking a position that public health and safety and keeping it out of the hands of kids is what trumps everything else. All the packages are going to contain all sorts of prescribed health warnings. There's a number of different warnings that are proposed to be prescribed in the regulations, and the producers and processors will have to rotate through those warnings throughout the course of the year and put all of them on their packaging. And as you can see, we've got pretty plain packaging. You've got the standardized symbol, you've got health warnings, there's some prescribed information, THC and CBD breakdown, and you're allowed to basically call your product something, you're allowed to give it a name, and you're allowed to have a small representation of branding and company name in the top right-hand corner of your package, but the text is black, the background's white, and everything is very genericized. And there's a lot of debate going on right now about, is that really going to advance the objectives of the bill overall or actually undermine it? So that's the federal framework, which is going to address the production and processing and distribution of cannabis. But as far as the retail sale of cannabis goes, that is all going to be done on a province-by-province basis. And again, I apologize because maybe on the when you get this later, you'll be able to see it with more detail, but I have prepared a breakdown between the provinces as to how they are addressing all the issues related to cannabis legalization, everything from minimum age, home growing, where you can consume it, how you can transport it, how it's going to be sold, who's going to sell it, whether there's going to be online sales or not. It is literally different in every single province and territory across the country. So, if you are traveling across the country, you'll have to, take note of the rules in that particular province because they won't be the same as you move across provincial lines. We're starting to see now the provinces, really get ramped up for retail sales, and they're starting to. I think this is New Brunswick's mock-up of what their cannabis stores are going to look like, and we've got Ontario releasing what the name of their stores is going to be, the Ontario Cannabis Store, the OCS, and what their logo is going to look like. And they're hiring, they're signing supply deals. I mean, the infrastructure is being developed, and everything is moving forward rapidly, despite the fact that this bill hasn't been passed by the Senate yet. Some of the provinces have already passed legislation, like Ontario and a few others. Some have bills in progress. A few, like BC, have yet to introduce a bill. But the work is well underway to put all of the legal framework and the physical infrastructure in place to allow this to happen. And I should mention that the Senate is supposed to do a third reading vote on the bill. June 7th is the scheduled date. It's in committee study between now and then. If it passes and without amendment, or if any amendments made are approved by the House of Commons, then we'll have royal assent very soon thereafter. We'll see the regulations released, and we can anticipate that everything will come into force, both the federal act and I would expect the provincial acts as well, at the same time, probably in August or September. So that's kind of the timeline that everybody's working toward right now. Now, I'm not a labor and employment lawyer, so I'm not going to get into this too much, but I just wanted to make the point that each provincial legislation, again, takes a slightly nuanced and different approach to consumption in the workplace. And so, depending on what province you're in, you would look to the provincial act, obviously, to see what those rules are. And typically you could expect to see some type of prohibition on consumption of cannabis in a workplace, but there are, it's important to pay attention to what is being prohibited. Is it smoking only? Is it smoking and vaporizing only? Is it enclosed workplaces only? I note in Ontario, it speaks to a prohibition for sure on smoking and vaporizing. or any other consumption in a prescribed manner. We haven't seen the regulations yet, so we don't know if those regulations will also include a prohibition on consuming edible cannabis products, for example, in the workplace. So if that isn't prohibited by regulation, that would be something that an employer would need to address by policy. There are some exceptions. You get into tricky territory when you have workplaces that are also residences. So for things like long-term care homes, there are special rules in Ontario about designated consumption rooms and how to protect the rights of workers to not be exposed to smoke or vape, but also to still respect the rights of those consuming cannabis. And of course, the medical consumption of cannabis is a whole different ball of wax because of the human rights issues that arise. Okay, so I think that's it for me, and I'll pass it over to the next presenter.
Great. Trina, thank you very much. And I think for all of the listeners, that's a great backdrop to start the next portion of the discussion. And in a moment, we'll turn this over to Matt Letson and then Tracy Kay, who will talk more specifically about marijuana use and its implications for employers. And I suppose one finding that resonates with employers is a finding that researchers published in the British Medical Journal in 2012 that marijuana use had roughly doubled the risk of motor vehicle crashes when the researchers conducted two meta-analyses in that area. And I think for employers, that's one of the concerns, that marijuana use can very well increase safety risks and create cause for legitimate concerns for the safety and well-being of employees. And so right now we're going to hear from Matt Letson, who will talk about the concerns that employers have been expressing and how those concerns might be resolved. So I'll turn this to Matt now.
Thanks very much, Kelly, and thanks, Trina, for introducing the new legislation. And I'm actually going to start essentially where you left off. First, I'm going to identify what the problem is with marijuana, and I don't know, I think this will come as news to most of you. Marijuana impairs. It creates a high, apparently. And so this creates a challenge for employers. It's going to create a challenge for law enforcement in terms of motor vehicle offenses and that sort of thing. But I know that will be surprising. This was chronicled in a report that was done leading up to the introduction of the Cannabis Act. This is a study that was done by the government, led by former Justice Minister Anne McClellan. And one of the conclusions of the report was that marijuana impairs a number of brain functions needed for safe driving, such as coordination, judgment of distances, reaction time, etc. And of course, while they were focusing on driving there, it also applies obviously to operating heavy equipment or working really in any workplace because of attention span and reaction time and all of that. But actually the real problem for employers is that in contrast to alcohol, there's no breathalyzer. There's not any scientifically valid way of determining when a person is impaired by marijuana. I see that there's a question. Are those impairments of a different nature than those experienced from alcohol impairment? I believe that there are some parallels and there are some ways in which they diverge. Often I think the analogy is made not necessarily to alcohol but to fatigue. that a lot of the symptoms or a lot of the impairments that you see in marijuana use are analogous to fatigue.
And if I might, Matt, just in response to that question, I think it's useful to take into account the fact that research tells us the impact of marijuana are different from alcohol in the sense that the impairment tends to last for different durations and can be differentiated still based on the manner of ingestion, whether by inhalation or oral ingestion. And so I think that's a very good question about the distinction between alcohol impairment and marijuana impairment, and then the subdistinctions of marijuana impairment based on the means by which it occurs, all of which are concerns for employers.
So just to follow up on that, in 2004, the National Highway Traffic Safety Administration did a report called Drugs and Human Performance Fact Sheets. And in that, they list that for marijuana or cannabis, the metabolite can be detected in urine for up to 3 days with single use, up to 5 or 7 days with use around 4 times a week, up to 10 to 15 days with daily use, and for more than 30 days with long-term heavy use. But the existence of the metabolite in urine or saliva or blood doesn't tell you whether someone is impaired. And there are guidelines around impairment anywhere from 8 to 24 hours, depending on, as Kelly said, the manner of ingestion, the concentration of THC, and so on. But there's by no means a standardized determination as to how long someone is impaired after ingesting a certain amount of THC. So the difficulty that poses is, well, if you have a chronic or heavy user of cannabis, they may have a high level of THC metabolite when tested and yet not be impaired. Someone who does not smoke marijuana may be impaired after a very small amount. What is emerging as employers have had to cope with this under the current law, and as employers are considering what's going to happen down the road with legalization, is what I call essentially a proxy that's not quite analogous, but would be similar to the blood alcohol concentration measure that we use currently for the criminal code is 0.08. For other measures, it's lower. In alcohol. For marijuana, the proxy is set in this Canadian model, which is a model that was developed in the late 90s for the construction industry and has been largely adopted in that industry for unionized workplaces. This Canadian model sets a rule that no employee shall report to work with an alcohol level equivalent to 0.04 grams per 210 liters of breath, and then sets a limit on the presence of drug metabolites. And if I just skip forward a few slides here, I can show you, depending on whether the test is a urine test or an oral fluid test. For urine, it's no more than 50 nanograms per milliliter of marijuana metabolite. For marijuana in saliva, it's 4 nanograms per milliliter on a screening test, and a confirmation test. If your concentration is higher than 2 nanograms per milliliter, then you're in violation of this Canadian model. The Canadian model provides that if you are in violation of that, you can be terminated, so discipline up to and including termination. And this Canadian model, at least in the unionized context, has been upheld in a number of cases. I cite a few here. There's no reason to think that if this was adopted by an employer who's not in the unionized context that it wouldn't also be effective, although I'm not aware of any cases where that has been done and the use of this policy has been challenged outside of the unionized context. We're not alone in using this proxy, as I call it, the 4 nanograms per milliliter initial test, screening test, and 2 nanograms per milliliter for the confirmatory test. This has also been adopted, at least in proposed guidelines, at the federal level in the United States. You see down at the bottom 4 nanograms per milliliter initial and 2 nanograms per milliliter confirmatory. And this is, I think, under the amendments to the criminal code that are proposed when the Cannabis Act comes into force, it would be a 5 nanograms per milliliter confirmatory test and 2 nanograms per milliliter to confirm the presence of marijuana metabolite. That's going to be the standard used for drivers. Again, I think that that's going to be subject to challenge because it does not necessarily demonstrate impairment. It's just what's been adopted in the absence of having a scientific demonstration of impairment. And I think that both in the workplace and likely in for roadside, you're going to have other tests that are going to be necessary to also look at whether someone is impaired. You can't simply rely necessarily on the concentration of marijuana in saliva or urine. I want to move next to the testing procedures and what's permitted under employment law. Under unionized workplaces, there are much more rigorous tests that have to be met. Under non-unionized workplaces, essentially there are no restrictions on the type of testing that can be done except where there is an addiction or other mental health concern that comes into play, and there are restrictions that the Human Rights Act would place on that. In the unionized context, in order to justify random testing, which is what a lot of employers have attempted to do, you have to have a history of drug abuse in the workplace. It has to be safety sensitive. And in fact, there's a very specific set of criteria that have been set by the Supreme Court of Canada in a recent decision, 2013, in relation to alcohol testing, although it has been applied recently as well in drug testing cases as well. The more likely to be upheld type of testing is where there's reasonable cause or post-incident testing. Those are generally more justifiable, but not always. The post-incident testing, it still has to be a serious incident. It can't be a simple minor accident at work that will justify the intrusion into privacy that happens when you test for drugs or alcohol in urine or saliva. So I've cited this Irvaz Regina Steel case where an employee simply backed a truck up in the parking lot, rubbed a guardrail, and the arbitrator held that that was not serious enough to justify testing, and so when the employee refused to be tested, that was terminated. The termination was overturned. So the policy has to be narrowly crafted so that it doesn't capture every possible incident or accident. And that's a recent determination in a Ontario arbitration. For reasonable cause, this is where you smell the presence of marijuana on the person or something to that effect. There are restrictions on that as well. In this United Steelworkers case, the employer tried to have drug sniffer dogs at the gates, and it was determined that that's overly broad because it was shown in the evidence that you could be sitting next to someone who has consumed THC, and the dogs would alert to that even if you didn't have, even if you hadn't consumed it. And in this resource development case, an employee's behavior was said to be erratic, and so the employer tried to have them tested for drugs or alcohol, and that was overturned because the erratic behavior was actually related to depression over a terminally ill relative. So you still have to, even though you can justify testing for reasonable cause or for post-incident, you have to be sensitive to the specific circumstances of the employee. To justify randomized testing, the test is much more strict. The concern being balancing the privacy interests of the worker with the safety in the workplace. And the Supreme Court of Canada decision, Irving Pulp and Paper, sets a lot of those, a lot of the criteria that have to be met. I won't go through them in too much detail. They really, in that case, put privacy at a very high premium. So they, relying on privacy cases dealing with criminal cases, they have said that privacy is something that has to be highly protected in a unionized context. Looking at the non-unionized environment, in order to terminate an employee, there must be just cause. The key is you have clear written policies in place, and Tracy's going to talk to you about what those policies should look like. But if you have clear policies in place, as long as the introduction of those policies don't amount to constructive dismissal, then if there's a violation, an employee arrives to work impaired by drugs, and you test them for that and determine that yes, there was the presence of marijuana, you should be justified in terminating them. It's a much less rigorous circumstance than unionized employment. A couple of cases, just as an example, even though you have a clear policy, in this case, this Morin and Gulf Operators case comes out of New Brunswick, an employee had been subject to a random urine test, had failed to be able to produce a sample, and was terminated for tampering, and the court held that the employer was not justified in terminating that employee. And in this Walker and Imperial Oil Limited case, there was a drug and alcohol policy in place. The employee denied that he was alcoholic, and the employer was justified in terminating when he had showed up with a 0.089 blood alcohol level. And even though this case deals with alcohol, it shows an example of how an employer can rely on a clear policy to terminate an employee where they have been found to be in violation of that policy. The exception, as I noted, is if an employee has an addiction, then the human rights obligations, and I think Tracy is going to talk about the obligation to accommodate an addiction as well. So I'm not going to go into the details of that, but just be aware that even if you have a clear policy and you're in a non-unionized setting, you're still subject to human rights obligations. And so I'll just close on what the Supreme Court of Canada said in Irving Pulp and Paper about balancing the interests of privacy versus the safety requirements of employers. The Supreme Court was specifically taken with the idea that employers should attempt to have every alternative to provide a safe workplace attempted, and if it fails, then justify random testing. So it just demonstrates that the privacy interests that are at issue when you're talking about random testing or testing for drugs and alcohol are extremely important and viewed very significantly by the courts.
All right, great. Thanks, Matt. I think most employers would agree that the whole topic of marijuana and the legalization of it and its potential use in workplaces is confusing. I think it's maybe somewhat comforting for employers to know that that confusion has extended into other fields where there's a lack of uniformity of views on impairment in respect of how marijuana is used, and what form it's used in, and how long the impairment lasts. But there are answers, and as Matt has pointed out, for employers, there are solid approaches to take in response to the potential for marijuana use in your workplace. So we'll turn it over now to Tracy Kay from Minden Gross in Toronto, and Tracy will talk us through some of those concerns that employers have, as well as some of the potential responses that you might want to consider. So Tracy, I'll leave it to you.
Thanks very much, Kelly, and welcome everybody. Thanks for phoning in. I wanted to highlight that if you're feeling in a fog as an employer about what to do and feeling a little bit uncertain, you're not alone. A recent Globe and Mail article referenced the Human Resources Professional Association survey that found that 71% of you are all feeling like your workplaces aren't ready for what might happen in what will be coming down the pipe, and certainly we'll be seeing it towards the end of the summer. So my goal is to try and give you some advice on how to walk through those steps to get ready. And I think we have to pause for a moment and step back and realize that for most employers, you're already dealing with many of these same issues in the workplace. You have to normally deal with, employees who show up for work who've been drinking too much the night before, or who are taking prescription drugs that might impair their ability to do their job. So it's the same sorts of tools that you're going to use to put together an approach with respect to marijuana in the workplace. And that is, assessing whether the employee can do the work, and if they're impaired, how to manage that and how to accommodate if that's what's required. So I think the first step that I'm asking employers to do is take a pause and spend some time between now and the next couple of weeks to assess sort of what your culture is regarding cannabis in the workplace. The nature of the workplace, the types of jobs that employees are doing, what the safety sensitive aspects of it, and come up with your approach to this topic. And speaking from a Canadian perspective, even each of our provinces, as Trina's shown in that chart that she put up, that each of our provinces are dealing with this and what happens in the workplace in different ways. So you'll have to look at your local legislation in your province to determine this when you're considering sort of what the culture of your company is going to be. And because marijuana has been an illegal substance, there's a lot of uncertainty from the employee's perspective about what it means when it becomes legal. When they think something's legal, they might think that they can bring their brownies into the workplace or vape in the workplace or do whatever in their cars at lunchtime and show up in the workplace. So it is a lot about managing the employee's expectations and setting clearly what it is that the employer expects from employees in the workplace. And this, as I said, is no different than what you might do about call-in procedures, about approving overtime. You have to set out the rules of your workplace. And I've given you a list of things to think about, whether it's smoking at lunch, and some of these are going to be regulated by statute. But as the culture develops within the workplace, it's coming to a sense of what kinds of issues are going to come up and how you're going to address them. So starting with a place where it's zero tolerance, then making sure that employees understand that's going to help you along the way. We have to look at sort of the balancing of certain things. For instance, if it becomes a legal substance, some authors have thrown out the idea that, well, if you're serving alcohol in the workplace and now cannabis is legal, maybe, those Christmas parties are going to get a whole lot more exciting. I don't know. But these are the issues that, you're going to have to address in each of your workplaces when you're looking at this and looking at the laws that we have. And I think when you're approaching my focus on the tips that we're going to put in, that I put in in effect and given you in the next couple of slides, is really from a non-unionized workplace perspective. But it's breaking down this into various components. You know, you might have a different approach for alcohol, for recreational marijuana, for prescription marijuana. You have to have a different approach. The same with prescription drugs or over-the-counter drugs that might impair someone's ability to do the job. And then you can have a very different approach with respect to illegal drugs. So thinking about each of these aspects when you're developing your culture, when you're developing your policies, is going to be very, very important. So then let's look at what kinds of things you should put into your policy. We've talked about expectations, and you know, most workplaces are going to start with an absolute prohibition against the use, possession, and impairment in the workplace. And you know, I think that the legislation talks about vaping, and talks in Ontario, for instance, and talks about smoking in the workplace. But you know, what about possession? What about the edibles when they come? As Trina said, that's sort of a regulated substance. We don't know what the regulations are going to say yet about that. So what about all those other aspects? What are your expectations about that? And as we've heard from a number of from both Matt and Trina, that there will be a requirement to accommodate medical marijuana and other prescription drugs if an employee is suffering from addictions or from some kind of underlying medical condition where they're taking medical marijuana, for instance, to ease the effects of those disabilities. And I'm going to talk to you about that in a few slides. So, but that has to be addressed in your policy. We have to clearly set out in the policy a commitment to safe work environment. All workplaces in Ontario, for instance, and in other jurisdictions have an obligation to commit to providing a safe work environment for employees. And this is probably the biggest concern that employers have about marijuana, obviously, is not only that people might not be productive, but that they just might not be safe when they're doing their work. And so firmly stating the obligation, the commitment to provide a safe work environment gives the employer the framework to make an argument later from a legal perspective if they have to defend their actions of discipline or removal from the work site, that there was a safety component to it. You might consider in your policies having the employee have the onus of self-disclosing impairment, which is that they will come forward, and building a culture where employees will come forward and say, look, I just don't feel I'm able to do the job today because here are my issues, here are my medical conditions, here's my prescription, here's what I was doing last night, and I'm just not able to work. So we're trying to put the onus on the employee to recognize the safety aspect and bring it forward with the employer, and having a culture where that doesn't result in necessarily discipline or walking the employee or terminating them for cause, but looking at a method of counseling and treatment, and we'll deal with that as another point in a moment. So also putting the onus on the employee that if there is a medical issue, that they have to produce proper medical evidence in order to justify either the use of marijuana in the workplace or impairment that might come from using marijuana outside of the workplace, but they still have the effect of it while they're at work. And we'll have a few more details on that in a minute. Setting out in your policy the right to remove the employee from the workplace, modify their duties, especially if they're safety-sensitive positions. We want to make sure that our policies give the employer the right to do that. And then setting out the protocol for if there's a breach, and having a separate progressive discipline policy that the employer would then follow with respect to warnings or expectations, discipline, progressive discipline. And while you can have the policy in effect and say zero tolerance, if the employer allows there to be variations from that zero tolerance policy, and then they come along with one particular employee and fire for cause, a judge looking at that case later is going to say, well, wait a second, where's the consistency here? And so you have to make sure that you set out the progressive discipline steps, or if you have a separate policy, and that it gets followed. But outlining what your expectation is of the employees will be very important in this policy. Matt's talked about the right to privacy, and he's produced some case law to show how important our courts have determined the right to privacy is. And there's lots of reasons behind this, because obviously what an employee does in their private life is not something that can be regulated by the employer or necessarily by courts in some fashions. And so we want to make sure that we reference that right to privacy as long as it's balanced with these obligations of safety in the workplace. A confirmation in the commitment to assistance and counseling should be included in your policy. So again, from a human rights perspective, there's a indication that the employer is willing to, assist and consider and assess whether this was impairment as a result of an addiction or an impairment as a result of a medical condition. And I'm going to address that again in a minute. I seem like I'm saying that a lot, but I am going to get there. And Matt's talked about the testing process already, how it could, and from my perspective, it could and should be part of the policy so that employees understand when the testing will occur, how it will occur, and so that they understand what the process is if there's a breach or a suspected breach of this policy. And then, most employers should be looking at having an accommodation policy where an employee is accommodated if there is an issue with respect to their use. And I'm going to pause here for a minute and just talk about this, which is that in most of the Canadian jurisdictions, if the impairment or the use of marijuana is as a result of an addiction, that is deemed to be a disability under our legislation. And when there's a disability in our workplaces, employers are required to accommodate. The other use, it may be around a disability from some other issue that the employee may be suffering from, and the prescription may be the marijuana. And so as a result, it's very important that whatever policies are in effect, that you have this obligation to accommodate if it falls into one of those two areas. And then, it comes out of the potentially progressive discipline process to deal with accommodation and modifications in the workplace. And then if there's a breach of the modified work and continued abuse or breach of the company policies with respect to the now modified plan and the agreed accommodated plan, potentially then the employer would be able to follow through with the progressive discipline. So it can kick it out to a disciplinary process. A reminder that the obligation to accommodate is set out in the legislations in each of the provinces in the human rights codes, and it really is a very difficult test for an employer. They really have to accommodate to the point of undue hardship in many circumstances, which is a very difficult hurdle. And so it's something that employers have to take very seriously and make sure that they are accommodating as required. So that's what I think should be in your policies. If there's existing policies that you think, okay, I already got that done, Tracy, don't worry about that, I'm fine. I just want you to make sure you go back and look at those policies, because often employers have referred to illegal versus legal substances, and now marijuana is going to be a legal substance. And so we can't rely on those all policies. They have to be dusted off and fixed up. I recommend also when you're once you've developed your policies or as you're doing this, to go through all of your job descriptions and make sure that you take a look at them and clarify which jobs or parts of jobs are safety sensitive positions, because this will give you the opportunity in your policy to modify work or move people away from work if they're in breach of safety sensitive work. Can't stress enough the obligation the requirement from my perspective to train your management properly. We have a case that happened in 2012 here in Ontario where some construction workers died just before Christmas because of a faulty scaffolding, and of the 5 employees that fell, 4 of them were killed. 3 of the 4 had been smoking pot in the workplace on the same day, and they were on a scaffolding that only 2 people should have been on, with two safety lines. One of the employees who was killed was the manager, the on-site manager, who was also impaired and had been impaired with cannabis. And so as a result, that company was fined And it was determined that this was a very preventable accident, and the company was fined originally $200,000 at the Court of Appeal. It went up to $750,000. It is imperative that your managers know that they are responsible for making sure that these policies are used in the workplace and followed in the workplace by the employees. And if they have any evidence of a breach or use of pot in the workplace or impairment, that this has to be immediately addressed, and they cannot turn a blind eye and just say, oh, it's just the guys out there, giving them a break. They've been working hard today. This is not acceptable response. We've talked about privacy, so I won't really go through this, but obviously, if there's a medical condition, this is not something that management should be gossiping about with other employees. This has to be centralized with the Human Resources Department, so the left hand and the right hand know what is going on, so a proper plan can be put into effect. I think managers have to understand clearly how to go through a process of, if there is a breach, what happens, what they do, how the testing comes into play, when it should be done, ensuring any evidence is preserved, if there's, remnants of a substance, or if there's, damage done, or witnesses who saw things, that this has to be preserved as part of, the investigation into the process. I know I'm speeding along here, but training your staff, I think making sure that once you have your policy in effect and before the legalization comes into effect, that you sit down with your staff and walk through what your expectations are, the zero tolerance policy, outlining that there are resources available. Maybe consider having an EAP program put into effect so that employees have a backdrop that if they need some support on this, that there's something available. Potentially, making a commitment not to reprise for, self-disclosing. So at least if your concern is safety in the workplace, that's your focus. You get employees on side from a cultural perspective so they feel comfortable to disclose rather than trying to do a dangerous job. Ensuring, we talked about the EAP program. I think just walking through once an employee comes forward with either an addiction or a medical note, making sure that you drill down and understand exactly what's required, when they have to vape, how much they have to vape, where, that potentially I've said make sure that the doctor looks at the job description. There is a case where there was a painter who was up on a scaffold 17 stories off the ground, and the doctor said in that case, well, hey, if I had known that was his job and that was the nature of his job, I wouldn't have said he should be vaping or smoking at work. And so, making sure that the doctors look at the job descriptions and you review them with the employees so that we can understand what modifications are required. Finally, looking at balancing the interests. When you have a lot of employees who are concerned about secondhand smoke or odors, it makes them feel sick. This is going to be an interesting issue for unions as well on how to manage this. Just to finalize, to just talk about the fact that you want your policies to be enforced consistently, all aspects of it, against all employees at all times. And as Matt indicated, that you could terminate for cause if it's a non-medical or non-addiction, like not a human rights issue. If there's a policy that the employee breaches, that this may result in a termination for cause after going through the relevant steps of a cause termination investigation. Matt's already referred you to the model that is something that could be looked at as a resource and adopted. It's not automatically in effect. Just a reminder, that is something that you'd have to take the pieces of and put into effect in your own workplace if you're a non-unionized workplace. And I've just given you the reference on my last slide to the Crown and Metron case, which is the case where those unfortunate deaths occurred. So that wraps me up right at 3 o'clock. Back to you, Kelly.
Hey, thanks, Tracy. We have a question. The question that's been posed is this. If an employee has an addiction issue or is prescribed medical marijuana to a level of impairment, is the employer required to hold the employee's position until treatment is sought or until an accommodation can be considered? Or is the employee expected to be able to maintain employment? And this, of course, is what employers always hate to hear, but that's a complicated question. There are some basic principles to draw on in response to that question. One is that in the case of medical marijuana, or for that matter an addiction, we know that there appears to be a disability, and so consequently human rights legislation would be triggered and potentially applicable. If that's the case, then obviously the employer may well have an accommodation duty, and likely does have an accommodation duty, and it's that accommodation obligation that would require some careful thought and application. So in my view, the answer to the question is that an employer would not be in a position to simply dismiss the employee because there is this impairing prescription for medical marijuana in play. Instead of that, I think that the employer would have an obligation by means of accommodation to consider alternatives and to ask for some additional medical information from the employee's physician, because it's the case that physicians are intending to avoid impairing prescriptions when possible, and so it might be the case that the employee's prescribed medical marijuana could be altered in form such that the CBD content would be made higher and the THC content lower. It might also be the case that the employee could be provided with a lower dosage of marijuana and some other treatment formula to assist. But in short, I think because it's a complicated question, I would say the first answer is that yes, the employer would have an accommodation duty, and that accommodation would require meeting the requirement that there be undue hardship before there's a dismissal. Matt, do you want to chime in on that?
Sure. I think it's a little bit of a complicated question in the sense that it's going to depend on a lot of factors, like what is the actual position of the employee? Is it a safety-sensitive position? Is it not? What alternatives have been considered by the physician for treatment? What has the doctor done to try and reduce, as Kelly said, the impairing effects of this treatment? There's not a lot of case law right now on trying to sort out all of those complications. There's really only one or two cases that where medical marijuana has been brought directly to the fore in the case. So as the court tries to figure out what are the duties of the employer to accommodate, and what are the duties of the employee to participate and cooperate in the accommodation process, and that's an important principle. Employees, I think that they can show up with a prescription and say, look, I'm covered. Well, actually, I think as the law develops, there's going to be concentration on what the employee's obligation is to cooperate in finding a non-impairing level of medication for cannabis. And so I think that will be an interesting development as the case laws work through.
And everyone, I know that we're slightly over time. Oh, sorry. Go ahead, Tracy.
No, I was just going to say, I think one of the key issues that was asked too was whether they had to hold the position for the person while they sought treatment. And this is in most cases this is not a statutory protected leave per se, although it could fall under one of the medical leaves available. And so there is some flexibility with respect to you have to get your job done. You have to, continue to do the work that that person was doing. And so it may be that you have to look at it as a temporary, replacement for somebody while they can't do the work. And if it becomes sort of a longer hardship on the organization, it may be that there are other factors that you could consider to do a permanent replacement. But I think this, as has been said, this is a complicated legal issue and has to weigh out how long the employee's been with you, how long they're going to be off, the nature of the job, if they're the only person, if there's 17 other people doing the same job. There's a lot of factors that would have to come into answering that question more thoroughly.
Right. And thank you, Tracy. A couple of more questions have popped up. One is, are employers able to, or should employers ask employees about any medical and addiction issues prior to the change in the marijuana legalization in order to make an accommodation? That's an interesting question. What I would say is that employers should read through the Supreme Court of Canada decision in Stewart and Elk Valley from the summer of 2017, really briefly stated, and I see people are having to depart based on our timing here, but very briefly, Stewart and Elk Valley is a case that you can find on CANLI, CANLII.org, and it's a case that suggests that an employer may well be in a position to implement a drug and alcohol policy that would require disclosure of an addiction in safety-sensitive circumstances. There are lots of complications to consider here, but in safety-sensitive workplaces, you might be able to consider requiring disclosure of an addiction up front, and failure of the employee to advise you of that addiction could result in dismissal or significant discipline if the addiction ends up causing a safety-related incident at work at a later date. So that's the short answer to that question. And then there's a question if an employer defines all positions in their operation as safety sensitive, does accommodation mean having to create a new non-safety sensitive job duty? First, the definition of all positions in an organization as safety sensitive will likely be problematic, but it's possible to conceive an organization that could be that way. But secondly, if all of the positions were in fact safety sensitive and there was no option for somebody who required, say, medical marijuana treatment while at work, then my thought process is that the law doesn't contemplate an employer's obligation to create a brand new position that would be non-safety sensitive. That's my short answer on that. Matt, do you disagree with me?
No, I think that's probably generally right. Again, it's going to depend on all the circumstances of the case, and also it's going to, you've got that duty on the employee to find ways or cooperate in the accommodation process. So they can't demand the perfect job for them. They have to cooperate in what the employer's efforts are.
Okay, there are two more quick questions, and I apologize, everyone, but we do want to try to maximize the value of this call, so we'll be quick. The first question remaining is if there are conflicting issues, like a recovering alcoholic or an asthmatic who cannot be exposed, do we have any guidance on how to resolve those? If I understand the question correctly, an employee in your workplace, for example, might be an alcoholic, and for privacy reasons you can't disclose that, obviously. Well, how can you resolve that issue? My thought process is that again, it comes down to accommodation, and the accommodation principles that are quite well formulated now based on the case law, the human rights decisions across Canada would provide guidance on that front. And so I'll make this suggestion to the person who asked that question. If you would like to email me that question, I'd be happy to engage in an additional discussion about it. And the last question is...
Sorry, Kelly, maybe I can just add one thing. I think it's the competing interest, and this is something that's the problem. Like if you have someone who's, has to vape or for medical reasons, but you have an asthmatic working side by side, and employers have to balance this all the time between competing interests with respect to, employees who have different needs. And so, yes, please go ahead and address this with Kelly. But I think that's the nub of this question, and it's a tricky issue that needs, consideration of both employees' interests and their specific needs.
Oh, I understand it now. Okay, well, if that's the case, I agree with Tracy that I think there will likely have to be some thought by the employer as to how the two balancing interests, or the two competing interests, can be balanced. And so I think there would have to be some creativity applied to that problem in order to provide, for example, the employee who requires an opportunity to vape with their medication requirements while minimizing the effect on the asthmatic employee who might be affected by that activity. So I understand that question better now.
If I could just say quickly to this is Trina, that it may also that question may be answered for you by the provincial legislation. So in Ontario, for example, you can't vape in the workplace, and we may end up seeing a human rights challenge to that for medical cannabis users who need to vaporize their medication during the day. But that's the position currently taken in the legislation. So you don't even need to make a compromise or a balance in that case because the employee would just be prohibited from doing it.
Great point, and that is helpful, Trina. Thank you very much. The last question that we'll answer right now is if we could recite the Supreme Court of Canada decision that references an employee's obligation to disclose an addiction, and we sure will. If you go to the website CANLI, CANLII.org, first of all, if you're not familiar with that site, it will make your participation in this call worthwhile, if nothing else has. And secondly, the decision you want to look for is Stewart, S-T-E-W-A-R-T, v. Elk Valley Coal Corp. And it's a 2017 decision. If you type in Stewart and Elk Valley, I'm sure that the platform will produce the case for you. It's a 2017 Supreme Court of Canada case, and I think you'll find it interesting. And my final comments are these. I'm really pleased that we were able to have the participation of Trina Fraser at Brazo Cellar Law in Ottawa and Tracy Kay at Minden Gross. I think everyone on the call would agree that their insights have been extremely helpful. Matt Letson here in St. John was able to talk us through some of the legal context that employers have to be aware of and cautious about. And I think Tracy's comments here at the end have given every employer some concrete steps to follow, which is really useful. So those slides should be available for your review, and we hope that this has been helpful to you. I do encourage you to speak to your lawyer if you have concerns about this impending legalization of marijuana. And if you don't have a lawyer, I encourage you to call Trina or Tracy or Matt, and I have every confidence that they will be able to help you. And with that, I'll turn it over to Crystal, who's done a great amount of work to help put all of this together today. And I just want to say thanks to her for her efforts.
Thank you, Kelly. I second all the sentiments that you just said. It was a pleasure to have each of you on today's webinar and to provide us with the great knowledge that you each hold. Before we sign off, just very quickly, just a reminder that I will be sending out a follow-up communication in the next couple days that will have everybody's contact details, a copy of the presentation, a copy of the recording. In the event you want to review it again or share it with somebody else, please feel free. Please feel free to contact any one of the presenters today if you have any questions that come up. And with that, thank you again for taking the time to join us, and I hope everyone has a great day. Goodbye.
Thank you, Crystal. Bye.
Thanks. Bye.